Article 13 is possibly the most important structural provision in the entire Constitution. It is not a right you can invoke. It is the mechanism that makes all your other rights real. Here is the simplest way to understand it. Without Article 13, the Parliament could pass a law tomorrow saying freedom of speech is canceled for everyone who criticizes the government, and the court would have no basis to strike it down. Article 13 prevents this. It says any law that takes away or diminishes a fundamental right is void to the extent of the inconsistency. That word void is powerful. Void means it never existed. It has no legal force. Not just suspended, not just weakened. Void. Article 13, Clause 1 covers pre-constitutional laws. These are laws that existed before the 26th of January 1950 when the Constitution came into force. If any of those older laws are inconsistent with fundamental rights, they become void from the date the Constitution commenced. Note carefully, they do not disappear. They still exist as text, but they become unenforceable against fundamental rights. This gives rise to the doctrine of eclipse. The doctrine of eclipse says that a pre-constitutional law that violates a fundamental right is not dead. It is only eclipsed. If the fundamental right is later amended or removed, the old law revives and becomes enforceable again. Think of a solar eclipse. The sun does not disappear. It is just hidden temporarily. The law is hidden under the eclipse of the fundamental right. Article 13, Clause 2 covers post-constitutional laws. Any law made after the 26th of January 1950 that takes away or abridges fundamental rights is void from the very moment it is made. For post-constitutional laws, the doctrine of eclipse does not apply. They are simply void. This gives rise to the doctrine of severability. If a law is partly constitutional and partly unconstitutional, the court will not strike down the whole law. It will sever the bad part from the good part. Only the bad part that violates the fundamental right is declared void. The rest of the law survives. Article 13, Clause 3 defines what counts as law. This definition is crucial and is tested directly. Law includes any ordinance, order, bylaw, rule, regulation, notification, custom, or usage having the force of law. So even a government notification, a municipal bylaw, or an executive order can be struck down if it violates a fundamental right. Article 13 is not limited to acts of Parliament. All state action in any form must conform to Part 3. Now the most controversial question that Article 13 generated. Are constitutional amendments laws under Article 13? If yes, Parliament cannot amend fundamental rights because the amendment itself would be void. The Supreme Court in the Goloknath case of 1967 said yes. Constitutional amendments are laws under Article 13. Parliament cannot amend fundamental rights. Parliament immediately hit back with the 24th Amendment of 1971. It added Clause 4 to Article 13, saying constitutional amendments are not laws under Article 13. Parliament can amend fundamental rights. The Supreme Court then settled the matter in the Kesavananda Bharti case of 1973. The court agreed that constitutional amendments are not laws under Article 13. Parliament can amend fundamental rights. But here is the catch that defines Indian constitutional law. Parliament cannot use this amending power to destroy the basic structure of the Constitution. We will cover basic structure in full in Section 3.19. Now your MCQ. The doctrine of eclipse under Article 13 applies to Option 1. Post-constitutional laws that violate fundamental rights, making them permanently void. Option 2. Pre-constitutional laws that become eclipsed when they conflict with fundamental rights, but can revive if the fundamental right is amended. Option 3. Constitutional amendments that abridge fundamental rights, making them temporarily void. Option 4. Any law that the President vetoes before it is assented to. Think carefully. The correct answer is Option 2. The doctrine of eclipse applies only to pre-constitutional laws. These laws are eclipsed by fundamental rights and become unenforceable. But they are not dead. If the fundamental right they conflicted with is later amended or removed, the eclipsed law revives. For post-constitutional laws, there is no eclipse. They are simply void under Article 13, Clause 2.